What's up, everybody? Welcome to podcast number 415. I am your host, Reality Steve. We got a good one for you today. We are going to discuss the Laura Owens, Clayton Echard case with a family law attorney who was on, I think, about a month ago, Judge Rachel Juarez from the TV show Hot Bench. But first, let me bring in my colleague here, Dave Neal, who has been covering this extensively since probably September of last year, right? Basically, right when the Sun story broke, right when Laura decided to go to the press with this. You've been on this, you've been covering this. You're probably sick of it, right, Dave?
I mean, yes, to my fellow colleague, thanks for having me. We blew past that 1 year anniversary. We didn't really celebrate. It's kind of like you don't want to celebrate these things. You want them to be over. But much like this Halloween day, there is a zombie lurking, and that is the story that won't end.
Yeah, no kidding. So let's bring her in right now. Rachel Juarez from Hot Bench. Thank you, Rachel, for coming on.
Thank you guys for having me.
My gosh. All right. So when we had you on a month ago, Rachel, I had asked you about the Clayton and Laura case, and we spent maybe the last 10 or 15 minutes of that podcast talking about it. And you just knew stuff from essentially headlines.
Yes.
Hadn't really gone into the weeds of anything. You didn't even know a trial had taken place yet. You were unaware of that. So I was like, I want to send you the main stuff that you probably need to see. It's impossible to get somebody caught up on every single thing that Laura has done, every sonogram that she has faked, every email dating contract that she sent Clayton. But I think I sent you enough of the main stuff where you were caught up. You watched the trial. You saw Judge Mata's judgment. You read her lawyer's blog the day the judgment went against them. A lot of things to get to here. So I guess I want to start off with this question. After getting caught up with everything, and I know there's probably a lot there, but is there one thing that stuck out to you that shocked you the most or surprised you the most once you actually read a lot of the things that went on in this case?
I mean, the obvious, which is probably that she's done this several times before. I mean, that is completely nuts. But I think what shocked me almost more as a woman than as a, lawyer is it is really not difficult to confirm a pregnancy when you're getting prenatal care. And the notion that she could be, going to high risk providers and get to 24 weeks pregnant, or not, obviously, but claim to get to 24 weeks pregnant and not have an ultrasound to date the pregnancy, not have any actual medical records to confirm a pregnancy, not having seen a regular provider. As a mother, as someone who's had 3 children, it's nuts. And I'm glad she had a female judge who maybe, understood the process, but that just kind of wipes everything else out for me because it doesn't make sense.
Now, you mentioned having a female judge. That's what's kind of scary to me is I kind of feel like she could pass this by to someone who doesn't understand what goes on. I wouldn't have, my wife was pregnant at the time, so I was learning a lot as I was going, but you get one ultrasound, you just take people for their word. What would a judge normally do to try to be impartial when they begin to look at that? Do they side with her initially?
I mean, so being impartial when you're a judge doesn't necessarily mean that you don't come in with your experience and common sense. Those are 2 things that judges and juries are supposed to use. So the fact that a judge might come in, with some background knowledge about pregnancy is not a bad thing. But yes, I would imagine, it would be hard to kind of set that aside and make sure that you're actually examining the evidence in this case. Maybe she's somebody who doesn't get a lot of prenatal care. Who knows? But I think it is good that she had a female judge because I do think it could be easy to say, well, she has a blood test. How could that be wrong? She has she urinated on a stick, in front of Clayton or not in front of Clayton. That's enough. Okay. She didn't get an ultrasound, but that's enough. And if you've ever been through a pregnancy, particularly one that's high risk, that's not even close to enough. You've had 5 ultrasounds by the time you get to week 24 for a high risk pregnancy. There is so much evidence of your pregnancy that having to scrape together one blood test is silly.
Yeah. And, we talked about it at the time. It just, it was the thing that when I was in contact with Laura, when it first broke and she was trying to get to me and trying to tell me her side, and same with Dave, it was just a lot of us scratching our heads saying the same thing. Like, pregnancy is the easiest thing in the world to prove. She's trying to go through every single loophole about this and RavGen and little to no fetal DNA. Well, it's inconclusive. It's just like, I had women emailing me during this saying, Steve, here's a screenshot of my latest OBGYN visit. And it was just the easiest thing in the world. Strangers that I didn't even know, and I wasn't even asking for it. And they were just like, this is all she needs to send you. And I remember writing Laura an email. It's like, Laura, just send me your latest OBGYN visit that from your portal. That's all I want to see, because then I'll know that it's legit. And she never even did that. She would move the goalposts and change the subject or not address specific questions that I asked her in email returns. And that's how we knew it was all fraudulent. So you saw the trial, you heard the way her lawyer presented things. I mean, I guess if you're defending her and you don't have that smoking gun of, here it is, this is our proof that she was pregnant, you kind of have to go through all these loops. And I mean, did you see during the trial what they were trying to do? Or you're just like, well, they tried, but if I was the judge, I wouldn't buy any of this.
I see what they were trying to do. I think it was a real miscalculation in terms of strategy. If it had been me, I would have just taken her through the first couple of blood tests that she claims to have, and then saved all my time for Clayton. And as you point out, when you sent me the, video and you said, are you through it yet? I said, oh, I haven't gotten to the cross-examination of Clayton yet. And you said, there isn't one, right? They wasted all their time first.
Yeah.
That just kind of to try to, paint him, because he didn't act very well, in a lot of respects, in the initial encounter with her, and nothing really untoward, but, he didn't submit those things to the real estate board. That wasn't, or to the, I guess, seller of the property. That wasn't great. But that's what I would have done, is I would have just put the couple of blood tests in. I guess they needed to get an expert, although their expert was pretty awful. And then just spent 45 minutes making Clayton look like an idiot is what I would have done.
So how often are you looking at motives for why someone would lie? Because, if anyone came up to a bar and told me they were pregnant, I'd be like, cool, I believe you. But when you see the articles where she's smearing Clayton, and of course, what wasn't in the trial is she faked this black guy who tried to cancel Clayton. She did all these things to really weaponize him. But like, as a judge, what would you look at? Like, she's not really looking for money. So like, you have to kind of look at the modern world that we live in of, well, I guess she wants some fame, some notoriety, something to talk about on her podcast.
She wanted to date him is what I took away from it, right? With the whole business with the, relationship, I'll be in a relationship with you if you promise me that it'll work, and then I'll have an abortion. I think that motive is important because it is kind of a bizarre thing to do. And I think if you have absolutely no explanation for why someone would do something this bizarre, and somebody who, before you dig down, doesn't seem like a nutcase just on the very surface, I would kind of want to know, why would she do this? So I think it does kind of help to put together the pieces of like, how could somebody, and why would somebody go to all this trouble to fake a pregnancy? And, so I think motive is important. It's not an element of trying to prove anything, but it helps put the pieces together.
Yeah, because early on, she faked the pregnancy in order to try to get him to hook up with her again. But then when she doubled down with us, it was more so, I mean, I guess at that point, we just had her on her heels, and it was like, try not to get caught, which would work for like your first 10 or 12 weeks of being pregnant, like maybe only, theoretically, but then every single day it went on, it worked against her that she wasn't able. I mean, she could have had an ultrasound delivered to her house in today's world. They have mobile ultrasounds.
Absolutely. And it at any point, once this blew up, she could have very easily gone somewhere and had a dated ultrasound. I mean, it would have been so easy to just prove that she was pregnant. But yeah, I mean, I think she very much wants to be pregnant. She wants to have somebody in a relationship with her. It's unclear whether she actually wants to have the child, but she's done this several times. And each time it's been kind of in connection with an attempt to lure someone into a relationship. And I even kind of suspected that what she might have been doing at the beginning was telling him she was pregnant so that he would continue to sleep with her and then actually get her pregnant, is what it seemed like to me. So that, you could kind of wash away the 6 or 8 week discrepancy down the road, because everybody knows, dating pregnancies is not perfect. And if it's 4 weeks here, no one's really going to know the difference.
So I think when this first started, the whole thing of her coming forward was, she said, and I don't know if you know Arizona law, but she said in the state of Arizona, if you get pregnant, you have to, put together some sort of parenting plan. And that was her whole thing. That I have a parenting plan, but he's the father and he's not responding to me. So I got to go to the media and tell this. So I don't know about parenting plans and all that, if that's even a real thing in Arizona. Maybe it is. But again, this started in family law. So then there was a pretrial hearing, and a lot of the stuff, when Clayton started finding out about the Greg Gillespies and the Mike Maricinis, that she had done this before, it turned into, well, that is like, is it pertinent to this case? Are you allowed to submit that stuff? Because in the pretrial hearings, Dave, wasn't it being shot down, or just like, hey, let's stick to this case, but in the future, well, maybe we'll get her during a deposition in a lie here. I always got confused about, were you allowed to bring in those other two cases in this particular family law case? Yeah, could you bring that in?
It depends, right? That's one of these very, very tricky issues. It's called character evidence in trials. We saw it a lot with things like Harvey Weinstein. Can you bring in other accusers? Can you bring in evidence of other bad acts? And the sort of concept behind it legally is, we don't want somebody to be convicted of something, or to be held liable for something, or to even just be judged based on collateral conduct that doesn't have to do with this case. So in other words, you don't want someone to be found guilty of robbery just because they're a drug user and a bad person. So they say, oh, they must have done this robbery as well. But there are a lot of exceptions to that, when the prior conduct is not just to show that they're generally a bad person, or that they generally have prior character. And in this case, to me, it's really her modus operandi. This is her MO. The fact that she has done this to more than one person in the past, it is evidence of the motive for doing this. And it is evidence that kind of, this is her deal, right? For something that's kind of initially hard to believe. Why would someone do this? The fact that she's gone through this entire plan twice before actually is evidence that she might do it a third time, as opposed to somebody who has, never done anything like this before, and they're just trying to prove, she lied to a prior boyfriend. Oh, well. This kind of shows she has a pattern and a practice of doing this. And so had it been me, I would have let in the evidence that she had done this before. I didn't hear much of it in the case itself. I heard kind of references to, you've done this to people before, but they didn't get into the details of, what did you do to Greg Gillespie? And my guess is that's because the judge said, we're not going there. We're not going to let you take anybody through the exact details of these prior incidents.
Yeah.
And they were there. They were in the court that day. They were supposed to be witnesses. They just obviously never got around to it.
I think if they had more time, they would have loved to hear that. But they were just, it was like being down by 3 touchdowns with 3 minutes left. Like, you got to go straight for the most important thing. But when we started covering the past instances of, Mike and Greg, that's when the defamation threats started to come in. That was like gasoline on the fire for her. And she specifically said, these cases have nothing in common, which is laughable, because yes, the previous case is slightly different, but it's the coercion that is like the through line. So every case she would get kind of smarter in a way, and have a new argument. With Greg, she tried to sue him for emotional distress, and they ended up dropping it after both sides spent a whole bunch of money. And now we expect a emotional distress lawsuit, because she's doing all of the things. She's lining up the weight loss and all of the emotional issues that the judge said she didn't have a paper trail for in last case. So you just know beforehand what she's about to do. You just can see it from a mile away.
Yeah. And that's exactly why, legally you might actually allow evidence like this in, because it shows that these are very conscious decisions. It helps to explain why certain evidence exists and why certain evidence doesn't exist, because she's literally done this before and learned from her past mistakes.
So you obviously watched the trial as well. And I mean, you've already given your thought on the fact that her lawyer spent much too much time with her on the stand. I think it was almost 35, maybe it was 40 minutes with Gingras going over stuff that the Judge Mata already knew pretty much all that stuff. That wasn't anything new, and it ended up hurting him in the end because he couldn't get to Clayton because the 2 hours ended with Clayton on the stand being interviewed by, examined by his lawyer, Greg Woodnick. So when you watched the trial, what are some of the main things that stuck out to you in terms of how Clayton's team did, how her lawyer did? Obviously, you've already kind of said the doctor that they brought up there as a witness. I mean, he was almost laughable because this doctor had never even spoken to or examined Laura in person ever. So it's just like, well, why are you even bringing this guy up as a witness? It didn't make any sense. But your thoughts overall on the trial and who made mistakes and where were the biggest mistakes made?
So I think the biggest mistake was the way that her lawyer examined her, because this is a credibility contest. I mean, that's really what this case was. This was not an issue of trying to figure out, what facts lead to a particular legal conclusion. This was, is she telling the truth? And did she file, ultimately what they're trying to figure out is, did she file this case with, bad motives, which is tied to, was she really pregnant? And her lawyer, instead of kind of letting her be the star of the show, letting her come on the stand and tell her story, her lawyer just led her through the examination and had her say yes, no, yes, no. So there was really no opportunity for her to get herself out there in front of the judge and get some sympathy and, and sort of convince the judge, maybe I'm a little kooky, maybe I did some bad things, but at the end of the day, I did think I was pregnant and I guess something happened to the pregnancy. That was really the only way I think she was going to get saved in this case, was by putting herself out there and really getting the judge to see her and her personality and, kind of come to believe her a little bit. And instead, her lawyer just walked her through a very leading direct examination where he was coming up with all the facts and she was just saying yes or no. And it really made it feel like she wasn't telling a story. This wasn't her here to come and tell her truth, to answer questions. It was her just saying yes to facts that her lawyer had already put in an outline. Similarly, obviously, there was a big discussion about, was the lawyer coaching her? And it looked like that from just watching the trial that, the part of the trial, I guess the view that I could see, it looked like an attempt to coach her testimony. Whether or not it was, nobody will ever know. But those things together really kind of gave up to me the one opportunity they might have had to say, oh yeah, she made a lot of mistakes, but at heart, this was someone who really thought she was pregnant and acted kind of bizarrely, but not maliciously. They blew it by trying to focus on proving that prior things that she had said were true, which was a huge mistake because it's ridiculous.
One of the questions I had was, how was it possible? There was a company called Ravgen, which did multiple DNA tests, which showed little to no fetal DNA, but they were based in Maryland. How was it possible to have like test results from another state that don't even get brought up? Like, it was almost like they had this evidence that didn't even come into play in the trial.
Yeah, I have no idea. I mean, it was so truncated. I mean, a lot of judges do this. A lot of judges put people on clocks. Given the stakes here, I was surprised there was such a strict 2-hour clock, but it absolutely makes sense for a judge to not let this go day after day after day. To me, it was probably a strategic decision they made just not to go there at the trial because they had such limited time. But who knows, right? I can't think of any reason it wouldn't have been allowed in evidence.
I wonder how this would have gone if we weren't there pressing her, because she was arguing with people on Reddit. Everything she was saying was getting deleted but saved beforehand. She really was going to be caught in a lie no matter what she said. And I guess everyone knew that. It was like, if you go left, we have the right. There was nothing she could have said that wasn't wrong. And, her lawyer knew that. Her previous lawyers dropped out when they found that out. It's like, well, what duty does a lawyer have to just recuse or like step aside when it's so clear the client's lying?
So no duty to step aside necessarily just because the client lies, but lawyers are not allowed to sort of put their client's lies before the court, right? So if your client goes up on the stand and says something that, you're not sure is true, and look, the defense for her lawyer here is going to be, nope, I think she believed she was pregnant. I don't know what is in her head. Nobody's ever going to be able to prove what was in her head. She's telling me she was pregnant and just doesn't have any evidence of it. So he doesn't know that she's lying. There's no ethical duty on his part not to represent her. I think his decision to sort of go full court press to the media seems very silly to me, but she supported that. So, if she's willing to let him do that, that's fine. And, I think that her responding back, yes, to the media, she was going to get caught in a lie one way or another, but it still hurt her because it still enabled them to bring in all of this evidence to court that they wouldn't have otherwise had, where she was trying to substantiate for you guys the pregnancy. And the defense that, well, we never presented that in court was laughable, right? I mean, it's like, well, first of all, you did present some of it in court at your deposition, but somebody who is lying to the media about a pregnancy, but choosing not to put that before a court is somebody who is very determined to lie and just maybe not lie too much. It just didn't, that fell so flat, that, well, I didn't send those to the court. I only sent those to the media. So it did end up hurting her, I think, that she engaged in that with you all.
We talked earlier about her lawyer putting a doctor up on the stand, and we find out this doctor had never even spoken to Laura and never even examined. This doctor was just put up on the stand after her lawyer showed him the paperwork, which was fabricated. And I don't know if you know this, Rachel, but during one of Dave's live streams is when he literally, as he's doing a live stream, is when he found out that, wait a second, she sent me an HCG level of 104, but I've also got one wasn't it during your live, Dave, that you realized she had sent 2 different ones to you?
It was right. Like as we were prepping, Meg and I realized, oh my gosh, I have a 102, or I have a 144,000, but then we got the real one, which was 102. So yeah, we were able to see exactly where she made these like sort of Photoshop moments. And this is the problem. It's like in today's world, when you know how to use these tools, you can't even tell things are Photoshopped. We would have had no idea it was Photoshopped unless we had the original. And that's a scary place to be because you get to hide behind your medical records. This is why everyone who fakes cancer fakes pregnancy. They're the 2 things no one wants to go near or touch. And the only reason we did was because she made it personal and we had to kind of, vindicate ourselves.
And, I'll tell you, I'm pretty sure if this actually had been going to trial on the issue of, her trying to prove that these medical records were legitimate, I don't think if there was an actual dispute about paternity or something like that, I don't think her photographs of a medical record would even have been allowed in evidence. They would have been inadequate as evidence and not authenticated. Somebody would have had to subpoena them from the actual provider. But because it became an issue of she fabricated it, obviously Clayton's attorneys wanted the fabricated evidence in evidence. So they put it before the court. But if for some reason this were happening in a different posture, I think there's a very good argument none of those records would even have been allowed in because of that exact reason. And a photograph of a medical record can very easily be altered.
And what we saw like early on was, because we've never dealt with this. So she would threaten us and say, you can't share that. It's my HIPAA rights. And we had to learn that that's kind of like, we can share anything you give us. But she got really good, at least early on, at trying to share things with us privately and then tell us not to report it. So, of course, we would share notes and she would send Steve something that she wouldn't send me because I was visual and he was audio. So she would kind of really play this game. And then, of course, we find out she faked doctors' emails from 2016. When it comes to the, looking at this as a bigger scope, you wonder like, yeah, sure. Why would anyone ever prosecute someone for lying in family court? But at what point do you go, oh my gosh, if we don't stop her now, she could be doing this in Maricopa County for 40 more years. Like at what point is it like they're a menace? They need to be stopped.
I mean, this point, right? I've told Steve before that, the notion that anybody would be prosecuted for perjury as a result of a family court proceeding is ridiculous to family court lawyers. You know, it comes up in every case. Someone says, my spouse, the father of my child, lied. Shouldn't they be prosecuted for perjury? And we laugh and we say, yeah, everybody thinks that. Obviously, I don't think it's a bad thing that they're pursuing this. It still shocks me because people do worse than this all the time. I mean, the number of people that have multiple serial restraining orders against different exes, the number is a lot higher than any of us would care to know. But I very much support that at this point, given what's happened, they would be doing this. It's still surprising because from a resource standpoint, prosecuting perjury is very, very difficult. And even here, it's going to be a lot harder to prosecute perjury than I think anybody is expecting because the bar to prove it is high.
Can perjury be what gets them to look into it and then they find other things and that becomes the bigger, so that's just the gateway?
Absolutely. Yeah, they have a sort of springboard to investigate. They don't necessarily even need a particular charge in order to investigate. There's got to be something, I would imagine, beneath the surface here that would be criminal in another way.
Well, that's what I was told. Yeah, that there's more.
Yes. I don't know exactly what, but this has got to be only the tip of the iceberg. And I wouldn't be surprised if they are pursuing this to end up really not even maybe seeing a perjury charge, but seeing other charges once they kind of uncover this. The question is whether they can make a case, because making a criminal case is a lot harder than, winning a civil case, because the burden of proof is beyond a reasonable doubt. And other issues like mental state, what you knew and what you didn't know, become more relevant, and those things are harder to prove. So that would be my guess, is that if you see a prosecution, it's either beyond perjury or there's not even a perjury attached to it. There's just, a lot of other charges, and maybe perjury is a tag along. Why not? You've got some pretty good evidence, particularly for her November hearing, that she clearly perjured herself in the November hearing. The other ones to me might be a little harder to prove, but that one seems indisputable by her own admission that she definitely knew she was not pregnant at that point and said, I'm 100% pregnant. I don't know how she gets around that one.
Yeah, no. And, I was bringing up Dr. Mitchell, the doctor that her lawyer brought up and examined, and just kind of the overall scope of that. And we talked about having a woman judge. And I don't know, obviously you read Judge Mata's judgment and it was 19 pages long. You had told me in the very beginning, like a judge giving more than a paragraph judgment is very rare. And the fact that Judge Mata went 19 pages to break everything down is something a lot of people said at the time. And then you basically parroted, which was, I've never seen anything like this before. You don't get that. And obviously you can't be in Judge Mata's head and we don't know what she's thinking, but do you think, number one, the testimony from the doctor, and number two, just the simplest notion that she was jumping through all these loopholes to show about pregnancy. Do you think ultimately that was the main thing? Is like, look, if we're talking about paternity here and whether Clayton was the father, this woman can't even prove she's pregnant. So how can I rule that Clayton had needed to do all this stuff in return? I mean, what did you think was the main thing or top 2 or 3 things that Judge Mata took into account to come to the decision that she did?
I think one of the things that was really important to her, regardless of whether or not Laura was pregnant at some point, was the fact that it was undisputed that she pursued this case for a while after knowing, even by her best case testimony, that she was pregnant. That is, for a judge, that is such a bad use of judicial resources. It is such a difficult thing to do to the other party and the other attorney. I mean, Clayton spent over $100,000 in attorney's fees. And that is a big amount, but it's not at all surprising to me for a case like this. Those attorney's fees add up so quickly for a case like this. To me, the doctor's testimony, they had to do that. They had to find some doctor. He had better credentials than who I assumed they could have found, but they had to find a doctor to say, I think she was pregnant. And it's not hard to find someone you can pay to say that. Finding an expert witness, And not showing them the right records is very common. You show them the records you want them to see, then they get cross-examined on it. But I think they at least had to try that. And I think it's because it gives a tiny little bit of legitimacy. Again, back to, is it possible maybe she really thought she was pregnant? I guess it's possible, right? If this doctor is even saying that, maybe we're at the 10% mark, even though it doesn't seem likely. But I think that for her, it was the misuse of judicial resources. And it was the insistence on continuing with the case, on filing for mediation, on doing these very specific things after knowing there was no case. And I really believe if she had immediately dropped the case in November, I'm not sure sanctions would have even been awarded.
Yeah, and when you look at some of the things, I know a lot of the things she did, like below the surface, wouldn't apply to the trial, but she was threatening Clayton to go to the press, and she was drafting up Instagram photos of the baby, announcement she was going to make. I mean, just vile stuff that anyone watches sees from a mile away, the coercion. But with a question I have about the expert witness is, he's retired. Does a judge take that into account to someone's credibility if they don't even have to own what they're saying anymore? Like, there's no pushback if he's just flat out lying because he's retired.
Yeah, there wouldn't really be any pushback anyway, probably, because his testimony at least would most likely to me fall in the sort of circle of, that's really silly and ridiculous, not lying. It's irresponsible to not look at all of the medical records. But if a lawyer only puts certain records in front of you and you want to reach a conclusion, I don't think it's likely he would have faced any professional repercussions for that, even had he been actively practicing, except maybe obviously looking foolish. And, it's certainly possible that the reason they found someone retired is because they knew that if this blew up bigger than, they thought initially, this person wasn't going to have a job to, answer to, or wasn't going to have colleagues to explain why he's being dragged through the media, so. But I don't think it's really, the doctors both had fine qualifications. To me, it's not an issue of, is this person retired? Does that make me look upon him unfavorably? The reason to look upon him unfavorably is A, he didn't insist on other records. And even worse in my mind is the fact that he said it would absolutely not change his opinion at all about what he reviewed if he knew that she had falsified other medical records. I mean, that's ridiculous when he knew he was relying on a photocopy of a medical record. And he said, knowing that she had fabricated other medical records wouldn't change my opinion in any way. It wouldn't even make me question my opinion, because that's just a different case. I mean, that's not someone who is trying to get to the truth. That's someone who's being paid to give a particular opinion. That's very indefensible, I think.
Yeah, he was basically answering a question nobody was asking, which is that, if you have 102 HCG, you have to be pregnant. There's a million ways to get to that 102 HCG that we could never find out why. But if here's a question I've had: what sort of boundaries do the prosecutors or the investigators have? Can they be tapping her phone line? Could she have been subpoenaed and then search her house? Could they have a warrant to search her house that we wouldn't know about? Would that all be stuff we would have known by now?
So this is a civil case. No warrants are issuing in a civil case like this. Nobody would have been able to search her house. Certainly no one would have been able to wiretap her phones, because this was not a criminal investigation with any of those criminal techniques available. Whether or not one of those things could be happening now, if they are pursuing a criminal investigation, absolutely possible. And it's also possible that nobody would know about it yet, because it doesn't really typically behoove an investigative body to tell everybody that they're going to execute a search warrant, or to tell everybody that they have a wiretap, right? You usually find out either later on or in higher profile cases when they show up to execute it. So you wouldn't have seen any of those things in this case because it was civil, but they could be doing that now, and they could be subpoenaing records and trying to put together a case, particularly given that they have cooperation from 3 gentlemen now to kind of, get the basics they need to then go beyond that.
Well, we talked about Judge Mata's 19-page judgment, and we talked about, her thoughts on the doctor. And I asked you, like, it's just, what were some of her things you think that led her to her decision? But in those 19 pages where she gave her judgment, what stuck out to you as someone who's obviously a family law attorney, and to see a judge do that and write out over 19 pages everything that she thought about the case? She really kind of laid into Laura. And, based on just me, the average layperson that doesn't really understand all of this stuff, even when I was reading that, was like, wow, this judge really doesn't believe anything that their defense team put together. What did you notice about the 19-page document?
So the reason you put together a 19-page document like this is to try to ensure that your findings, are preserved through appeal, right? She must have known that this was going to be appealed. And for decisions like this, like sanctions, there's usually a lot of deference given to a trial court in terms of weighing credibility of witnesses and choosing which facts are important and which aren't. And the more common bases for an appeal in a case like this are legal. You made a legal error. So it seemed to me like she really wants this. And by the way, this does not mean she's biased or acting inappropriately. She wants this to stick. She wants to make sure that she has the factual and legal bases for this sanctions award to stick. And she clearly went out of her way to make absolute sure that the appellate court knows that she evaluated the credibility of these witnesses and made very clear determinations about their credibility. Because evaluation of credibility is something that an appellate court can't say, well, you did that wrong. Like, I thought he was more credible than she was. They leave those decisions effectively to the trial court judge because they're the one that is sitting there watching them testify. So that was, I think, one of the things that stood out was she took pains to support her conclusions and actually make conclusions that her testimony was not credible. Same with their expert witness. Instead of just saying, I reject this witness's testimony, she went through and explained why certain testimony from their expert made the rest of his testimony not credible to her. That way, when you get up to an appeal and the lawyer says, well, there was an expert who said she was pregnant, the appellate court goes back and looks at the record, and instead of just having the testimony from the expert that she was pregnant, they have that and the judge's determination that for X, Y, and Z reasons, I rejected that testimony, and it was a matter of credibility. So she really kind of shored herself up as best she could for this decision to survive an appeal. And contrary to what Laura's attorney has said very publicly, that doesn't make her biased, right? There's other things that can make a judge biased. Going through a long decision explaining the bases for her decision does not make a judge biased. The fact that she wants this decision to survive appeal doesn't mean that she's acting improperly.
And speaking of appeal, we know it's coming. He has talked about it. I think he's got till, what is it, December something, Dave? December 20th to make this appeal happen, something like that?
Yeah, he's filed his notice of appeal, and I think he said he'll even try to go as far as their state Supreme Court, whatever that means. But we don't have any belief that he's getting paid. He's kind of just, in my opinion, kind of like the reason why I think this has been so fair is because there's been a lot of eyeballs on it. And you have to think, if you're Rachel Mitchell, the county prosecutor, and if she doesn't, with all the evidence that's out there, if she doesn't take a stab at this, people are going to wonder, they watch these documentaries and they wonder, how come nothing was done? So I feel as though it is big to start to get these things right in the world we're moving into with AI and all the artificial, truths that people can live. It's like, at what point will they put some bandwidth into trying to get everyone on the straight and narrow?
Right. Absolutely. And, trying to make an example of her is not a bad thing, right? That's one of the things when you're talking about criminal sentencing, people will ask a lot, oh, this was a high profile case. Is it unfair that they're trying to make an example of this person? It's not, because one of the goals of the criminal justice system is deterrence. They're trying to deter crime. And I think you're absolutely right. One of the, if not the only reason that we are here at this point is because of how many eyeballs there were on it. This kind of stuff goes on all the time in state court, and it gets way further than this. without consequence, right? Especially in the restraining order world, right? The number of people that pursue things well beyond what is reasonable, it's high. There's also legitimate cases, obviously, too. But I don't think it would be inappropriate. I think it would be very appropriate for the prosecutor to say, I want to make an example of her. I want to make sure she doesn't do this again. But I also want to make an example of her because this has garnered such national attention. I want to make sure that people watching this know if I try to do that, I could go to jail. It's a ripe reason to be that 1 in a million prosecution.
Yeah. And, I think the reason there's a lot of eyeballs on it is because, Steve and I, we try our best to get our content right. And probably more so than Clayton have audiences that have been with us for a good bit now. Steve, much longer than me, but people saw immediately, there's a lot of cases, Johnny Depp, Amber Heard, it might be 60-40. There's always like a shadow of a doubt, but we have yet to find one person. And Steve has begged people, come forward. I'll keep you anonymous. Just tell me if you are on her side. And nobody other than people she has paid for or her mother has even defended her.
Yeah, there's nothing defensible here. I mean, and it's because I think of the way she has approached this. She really could have easily gotten out of this, I think, if she had just taken the right approach, which is my bad. I screwed up. I was acting crazy. I did think I was pregnant. Then when I found out I had a miscarriage, I kind of did some weird things. I was still emotional. This did not have to go this way for her. It was the absolute doubling down and doubling down and doubling down that is why we're here. If she had walked away gracefully in November, I think the story would have died. I think you guys probably, it still would have been.
We would have taken a victory lap for sure.
Right. And it still would have been something that, that where justice was served because of all the media eyeballs on it. But she could have just slinked away and this probably would have fallen flat. I really don't think a judge, if she had dismissed that case in November, would have sanctioned her like this. Especially, this is a large sanction. It's going to be over $100,000. That's a big sanction, especially for somebody who makes $200,000 a year. This is a big deal and it's unusual. And the other reason it's unusual is because it was done sua sponte by the judge. This was a situation where Clayton filed initially a request for sanctions and it was procedurally improper under Arizona law. And so he ultimately withdrew it. But the judge said, you know what, I'm going to move forward on my own motion for sanctions. And that is allowed, but it's unusual. Usually judges are not themselves bringing sanctions motions of this magnitude. Smaller, of course, if an attorney is, misrepresenting things to the court, not showing up to court, a $5,000 sanction from a judge is very common. But that's to control attorneys, not against parties. And so, the fact that this judge really brought her own motion for sanctions is also really remarkable as well.
I thought the judge was great. We were trying to read into her early on because she was so tight-lipped, obviously. But I think they asked for medical records dating back a year, and she said 4 years. And they had the 45-minute trial. She made it 2 hours. So we kept on seeing these sort of breadcrumbs of okay, she's taking this seriously, because we watched with our own eyes how Clayton lost his order of protection with Judge Duty, the Honorable Duty, the male judge who didn't understand how YouTube worked. We saw oh my gosh, this system does not necessarily work out. Clayton said, I've got this evidence that it wasn't me. And the guy said, I don't need to see it. And she tried to get a restraining order against me, and you see how it's used against you. Clayton, just the other day texted me that because of the restraining order, it's messing up his life in other ways. You can imagine with going through airports and applying for jobs. It's this, she wants to punish people. And we saw that from a mile away. So that's why it's sorry, it's not good enough where it stands right now. We need full, court rulings, investigators, documentaries, just truth needs to be out there because I don't need to wake up 3 years from now and see that she's got a book she decided to release that shares a side that rewrote the whole story.
Absolutely. And, you could tell from the judge's ruling, she went through a whole lengthy thing about how she actually legally could not reverse the protective order that Laura had against Clayton. Otherwise, based on what she wrote here, I'm sure she would have.
Sure.
But she went through and, you know, there's no collateral review of those things. I don't know if Clayton can still appeal that. I don't know what the deal is in terms of when that would have become a final order, whether the time to appeal has passed. But yeah, nobody, I mean, if he applies for a job and they run a background check and that restraining order comes up, no, the chances that somebody's going to come and find all of this and deep dive are probably small. They're just going to push his restraining order, you know, application to the pile as, you know, restraining order guy. No, thank you. And it's really bringing light to the fact that this is a very common problem in this country, right? There's, you know, the domestic violence system is broken in a lot of ways, but one of the ways in which it is broken is it is the ability to get a restraining order in some respects is easier than it should be. In some respects, it can be harder than it should be. But there is, you know, there are overworked courts that are dealing with, you know, truncated timelines, and it feels easier to just give a restraining order, you know, to protect somebody than, you know, to really go through everything that you would need to go through in order to like look at, you know, the validity of evidence. And so, and people don't have the resources to hire lawyers to take them through this process. I mean, imagine someone in Clayton's position who didn't have $100,000, you know, that person would be struggling themselves trying to prove that she fabricated evidence and might look ridiculous, right? Trying to prove that she doctored medical records. And the court would say, ha ha, yeah, she doctored medical records, you know? So I think that the more attention that can be kind of drawn to this, the better, because this is one of the few cases where you're actually having all of that hashed out and you're kind of seeing some of the flaws in the system, but also you're seeing the system work, because here the system appears to have worked. It's just a lot of cases don't get this far.
Yeah. And I think that, you know, when we had you on the first time, it was a lot about the Devon case, and we were talking about that restraining order and whether or not the show should have known and stuff like that. But you had made your opinion known about then that, look, the burden of proof is very low when it comes to restraining order, because just because she got one against Clayton doesn't mean he's this horrible person. It's very low, right? It's just, they basically just give it. Basically, it would be hard to not get a restraining order against somebody, right?
So on a temporary basis, yes,
Yeah.
right? And that's what changes this one a little, because she actually did go to a contested hearing and get one over his objection, right? So the bar to get a temporary restraining order is extraordinarily low. It is harder to get a permanent restraining order, legally and practically. But the fact that you already have that temporary restraining order is almost an insurmountable burden sometimes for people defending against a restraining order. They say, oh, they already got the preliminary one. Just forget it. You know, it's not worth it to me. I just want to go on and move on with my life. And a lot of people who would want to fight it don't have the resources to hire counsel, to, you know, it's very hard to defend yourself at an evidentiary hearing. I mean, it's an extraordinarily hard thing to do, even if it's a simple hearing. So, you know, it is not as easy to get a permanent restraining order, which he ultimately did, but the whole process sort of can be a snowball. I think that's the way to think of it. And getting a temporary restraining order is, in terms of burden of proof and practicality, very easy.
Yeah. And you know, the other thing that Dave and I deal with, more so Dave than me, because her attorney, David Gingras, has a complete hard on for Dave and will not stop talking about him. And it's truly amazing, because I feel like this guy doesn't understand that being a YouTuber and putting out content is an actual full-time job. And it's all he insults Dave for, and says, constantly saying Dave should get a real job and he should stop talking about this one. It just makes no sense. I mean, it's just, it's a public case. You're allowed to talk about it. Anybody can. And so the one thing that I sent to you was the blog that he wrote the day that Judge Mata's decision came down, and me not knowing anything about the legal system. It just didn't seem like a lawyer should be as verbose and should be writing the things that he did when he plans. And we knew when they lost this case, he was going to appeal. It just didn't seem like anything you want to do. And I know Mata wouldn't be the judge in the appeal, but I would assume people that she knows would be the judge. And he's sitting here just insulting her intelligence, saying she's biased, saying she's a Bachelor fan, the whole concept of her dad being in the overflow room, which he was. But I didn't know that until after the trial. And I got outside and I was talking. They're like, oh yeah, Mata's dad was there. And he's using that as some major reason why she was biased in the case. you read his blog. What do you think about his take on everything?
I mean, first of all, trials are public. If you want to come watch your daughter be a judge, you're welcome to do so on any case, unless it's a case that is not public for some reason. But look, this can't possibly help legally.
Yeah.
Right? It can only hurt him legally. What he's doing in the press, there's literally zero way that this could help the case. And there are a lot of ways it can hurt the case. If a future judge sees something in the press about it, if, they shouldn't really be reading his blog either, the judges, they should be trying to stay away from that. But the only possible outcome is it hurting his case. And so then it becomes an issue of, is it worth it to potentially compromise the case in order to get the media boost? And everybody that I've heard thinks he's ridiculous. So it's not like he's changing minds and winning hearts and doing that, which I could understand that calculus. If he and his client said, you know what, it might not necessarily help us to be doing this, but if I'm going to go out there and change minds, that's fine for my client. She would rather change the public discourse on this than, have a little bit of a trial, a little bit of a loss in the legal strategy area. But I didn't really see anybody that was responding to what he was saying, oh, that's an excellent point. Now I'm persuaded. He's just kind of digging and digging and digging in public opinion, and is insulting and trashing everybody who has built up credibility with their audiences, right? And so he's just swooping in and, coming to these people that have a long history with you guys, that trust you, that have known you for a long time. And, he's just digging his hole deeper. So I don't really know what the logic is from Laura's end. From his end, it's got to be that, bad publicity is worse than no publicity, right? That's getting his name out there has got to be worth it to him, whether he looks good to 90% of America or not. The one or two people out there that think he's famous and may hire him in a future case, that probably outweighs what everybody is saying about him right now in his mind, but it really makes you wonder whether he knows. And that's what I wonder when I read the blog. Does he think he's changing minds, right? Because he always makes these comments about, well, there's three kinds of people in the world. There's the Clayton people. There's the people that are genuinely interested in legal analysis and want to have an objective view of this case. And there are, something else, Judge Mata's father. I wonder if he really thinks that there's a big contingent of people who are coming for the legal analysis and believing what he says.
I think he likes to play the game where truth really matters, and don't get mad at me for being specific with the law, and that's kind of like the loophole game he's playing. But then when we present any evidence that contradicts him, he kind of has a little bit of some sort of kink fetish about getting dunked on Twitter, because you essentially have just a bunch of random people that nobody knows answering him and providing information that completely contradicts him, and then he just moves along. I always equate it to like someone who farts in an elevator and then gets off the next floor, and you're like, you can't do that. Like, we all know it was you. And that's kind of, so, we've wrapped our minds around why would Laura do this? And then we wrapped our minds around why would he do this? And I think in the end, he doesn't care what side he's on as long as he gets in the documentary. I think that's all that matters, because I don't think he's getting paid. A lot of people have said Laura's family is worth way less money than people think. They take out these predatory loans to buy homes, and they don't really have a whole bunch of cash. They say they do. And that's kind of what they use to kind of sink people. But, a lot of the bullying and things she filed, she did for free. Like, all of the tormenting she did to me, she was filing on her own. She didn't really have to put up much money to bully in the way that she did. So I think it's an example of maybe, Wizard of Oz isn't as powerful as people think. But if he's working for free for her, he can continue to, do these appeals and try to, maybe get his name on some sort of Supreme Court decision or whatever he's looking to get out of it.
Yeah. So no, I mean, the Supreme Court, by the way, usually, I don't know in Arizona for sure, but usually if you lose your appeal at the Court of Appeal, you get to go to the state Supreme Court if you want, to see if they'll take your case. So that's not anything like he's, this is going to be a special case or anything. He's just saying, I'm going to pursue this appeal all the way up, the ladder. A Supreme Court there's not going to be an issue here that's worthy of Supreme Court review unless there's automatic Supreme Court review in Arizona, I mean, this is a sanction award. This is not a novel legal issue. This is not a complex legal issue. This is a decision that somebody should be sanctioned for filing a case without a good faith belief in its veracity. This is not high-powered legal stuff here that Supreme Courts are going to want to take a look at.
So next is obviously the appeals process is next. So explain to the layperson, including myself, exactly when he files the appeal, then what will happen and how long does that process take? Is there going to be a trial for the appeal? We can go out into Arizona again and watch this. Can we do this?
No. So there will not be a trial. So basically what's happened is he has filed his notice of appeal now, which is something that you have a deadline for, saying I intend to appeal. That usually never has any much substantive information or argument in it. It's just to preserve your ability to appeal. It's a deadline issue. It's a jurisdiction issue. So he has a certain amount of time, I think until about December, to file his opening appellate brief. Then that triggers a deadline for Clayton to respond to him. And then I'm not sure in Arizona, but usually there's a reply brief. I'm not 100% sure if they have one in Arizona, but that would be typical. A reply brief from the appellant is then filed. So at that point, appeals are not trial courts. So there will be no trial. They don't take testimony. They don't have witnesses for these type of things. They can sometimes have witness testimony, but this is a review of the trial court's decision. They take the trial court record, they take the trial record, and those are their facts. And they review the decision. So nobody's going to come in and testify again. Nobody's going to be asked, to comment on the ruling. This is going to be a strictly legal, mostly written argument. And then oftentimes there's an oral argument that is permitted by counsel, right? Once it's fully briefed, and it's different in every state, counsel will often have an opportunity similar to what you see in the Supreme Court of the United States, where the attorneys come in and argue before the judges. But they don't put witnesses on the stand. They'll argue the legal issues. Appeals are in front of one judge or three judge, depending on the procedure, and then they'll issue a written decision. And this will all be a legal review of the trial record. So they're taking all of the evidence from the trial and basing it on that. The process for appeals is usually very long. It is a long process. It would not surprise me at all to take over a year from the briefing completion to a decision. It could be longer. I mean, these do not move quickly. It's very paperwork intensive, because if you imagine, the appellate court is going to get the entire transcript from this trial, the entire transcript from every hearing they've had. I mean, that's going to be the record that the appellate court has to review. And there's a ton of paperwork, and it's legal analysis, and they've got to basically go back and review the entire thing. So it can take a very long time.
Gosh, can't imagine covering this for another year. Well, we wouldn't really be covering anything because nothing would be public that is really going on. But obviously, that is completely separate from the investigation that's going on by Rachel Mitchell's office, right?
Correct.
So he can lose she could be indicted, but also win the appeal, or vice versa, right?
Absolutely, including because if she wins the appeal, it will almost certainly be for a legal reason, not because the appellate court says, we think you're a wonderful woman, Laura, you were telling the truth. You should have been, celebrated rather than dragged through the decision. It'll be because there was some technical procedural defect or legal defect, which are still important, but it'll be because, the judge didn't make the findings consistent with Arizona Code 472. I mean, that's what appeals tend to be, as opposed to just a determination that, in fact, she was right after all. And that kind of is the last step. If she successfully appeals, it is very possible that the appellate court is unlikely to just reverse the decision and change it to make it the opposite. Far more likely in this context, and I wouldn't know for sure till I saw the appellate briefs, but far more likely to say, we're vacating the judge's decision. This has to be done again.
Ugh.
So it's very uncommon in a situation like this for an appellate court to say, I'm going to change the decision of the trial court and make it the opposite, and now we're done. Much more common is the trial court did it wrong, so I'm getting rid of their decision, and now it gets done again. And if that happens, apparently in Arizona, which is fairly common, it goes to a different judge if it's remanded.
So regardless of the appeal, let's just a hypothetical. If you were, say, Laura's aunt, you saw her at the next Christmas party, what sort of advice would you give her from a legal standpoint for what she should be doing right now with regards to being investigated?
Stop. Stop talking. Stop saying anything. Put a muzzle on your lawyer. Stop giving them more evidence. Right? Because that's the problem, is every time her lawyer blogs something, every time she has to testify for any reason, right? If this case gets remanded and she has to testify again, that's more fodder, right? The best thing she can do to avoid criminal prosecution is shut up and go away. Because the more that this disappears from the ethos, the better chance that it will go the way of all other cases and there won't be a perjury prosecution, because that's what usually happens, is it just kind of dies down. But the more that this stays in the forefront, the more incentive there is, both for deterrence reasons, but also just for publicity reasons, to prosecute. And so I would probably tell her, give it up. I tell her, give up the appeal. It's not a good appeal, and I don't know for sure. I haven't seen the appellate briefs. There could be some legal argument I don't know about, but just the cost, of paying this judgment is bad enough. Do it, accept what happened and stop giving them more fodder for a prosecution.
Yeah, I've always said the most interesting, if she put her podcast, if she just came out and told the truth, it would be the most interesting podcast she ever had. She could completely rebrand and do a whole series about why she lied. Yeah. Now, her lawyer accidentally admitted that one of the ultrasounds that was used was Laura's sister's, Sarah. Does Laura have any grounds to come after her lawyer? Because we know she's come after previous lawyers and filed multiple bar complaints against her own lawyers in the past. He's the first one to actually admit one of her lies, it seems.
Yeah. I mean, yes and no, right? My guess is that she has basically given him the go-ahead to blog about this in the media. And I think she's probably unlikely to have much recourse against him if he says something that is true, but it wasn't one of the things she wanted him to say, right? Lawyers are absolutely not allowed to reveal client confidences. And if he had gone out on his own and said, hey, I'm working on this case and I don't want to tell you anything private, and then it slipped out, she'd have a lot of recourse against him. That would be really bad. But if she has kind of said to him, go make our case to the press, it'll be a lot harder for her to establish that she kind of, he shouldn't have said that one thing. And even if she can prove he shouldn't have said that one thing, that even the fact that he said it really mattered in the context of everything else that's happened, right? She's not going to be able to really prove damages of any kind, because the damage to her reputation is not because of that one admission. It's because of this whole thing. So, you're not supposed to reveal client confidences, but when your client makes you their spokesperson for the media, you kind of take the risk that one of the things they're accidentally going to do is slip up.
Yeah, and it was a big slip up. I mean, people were immediately able to show video evidence of her absolutely lying about that as well. Now, he doesn't have malpractice insurance. How common is that? I think it's because he had a DUI or something. But how common?
Malpractice insurance?
Yeah, I believe he doesn't.
Wow. That's wild. I can't even practice without malpractice insurance, right?
I think they wouldn't insure him because he was, there was a complaint. I think he had a DUI and he had maybe whatever the case was. That's my belief, because people find all these things out pretty easily. And everyone was like, oh my gosh, you idiot. She's going to be coming after you so fast. But I mean, I guess, knowing what we know about him, he seems to not really care. Yeah.
So him revealing something to the media, I don't think would be malpractice. Malpractice would basically be when you make a malpractice claim, it's that your legal services fell, below the duty of care, right? Which is a low bar. But also in a malpractice case, at least in California, you have to prove that the result would have been different without the malpractice. And that is extraordinarily hard to do because here you have to basically have a little trial within a trial to show the court, like, if the attorney hadn't done this wrong, I would have won my case. She's never going to be able to prove that in this case, particularly given Judge Mata's decision, but also just because it's such a high bar to be able to prove that you actually would have won your whole case, because that's kind of an intangible thing. What is so bad or so, significant that it changed the whole scope of the case? So I don't know exactly what her recourse against him would be for disclosing confidences. Clearly, she could go to the bar and complain about it, which would be unlikely to really get her anywhere in terms of, money or damages. But we know she's like a ruiner, right? She likes to go and try to ruin people, right? We saw, her going to the, board about Clayton and taking all these people to court. So if she and the attorney have a bad end, that's something I would obviously expect her to do, given her past, is go and make, state bar complaints about him. And, the fact that she's made state bar complaints about her past attorneys is one thing. Anybody who makes state bar complaints about opposing counsel is really when you know that you're deep in the weeds, right? Nobody likes the lawyer on the other side of their case, right? But to go to the state bar about an opposing attorney is really when that's low, and they laugh those off when somebody says the attorney on the other side of my case came, and complained. No, it doesn't work. So I would expect that she's not going to do anything as long as he's in her corner, partially because she's got to know it's going to be hard for her to hold on to a lawyer, particularly if she's not paying them. And I don't know if she's paying them.
What's interesting is there's just so many aspects where this is like, she probably loves being the star of this show, but sources have said she showed up to Clayton's deposition and dressed to the nines and made a whole thing and stayed there for like the 4 or 5 hours. How often do you see that where someone shows up to the opposing party's deposition?
All the time. So I will say first, it's very common for one party to go to the other party's deposition. That's very common because your lawyer, as they're asking them questions, needs you for help, right? If they say something, for instance, if they ask a question to Clayton, where were you on July 4th? And he says, I was at a party. And she says, no, I actually know where he was because I was with him. The lawyer's not going to know those collateral facts. So very common to have your client with you in a deposition. But the showing up dressed to the nines, trying to do that, it's something we see a lot, especially in divorces, right? People they don't want to show up in their sweatpants and, look schlubby. They want to show everybody what they're missing, So that didn't surprise me at all. And I imagine this is definitely, not only from her lawyer's standpoint, but from her standpoint, publicity is publicity. And, I don't know if she's embracing it now or if it's gotten so one-sided that she's trying to slink away from it, but she's clearly not doing everything she can to try to hide. Otherwise, she would have a lawyer muzzled, right? I mean, if what she was trying to do was kind of slink away from this, she put a muzzle on her lawyer, which she's absolutely allowed to do, especially while the case is ongoing.
Interesting. Yeah. I mean, just to wrap up a few things here, having watched the trial, having been briefed on everything, even seeing clips from the pre-trial hearing and stuff like that, reading Judge Mata's decision, it's just your outside opinion. Obviously, this is just your opinion. Did you see anything that Mata said in her decision that maybe you disagree with? Do you believe Laura in anything here? I mean, what is your overall take on this case? Do you think?
So
what is your thoughts on it?
Right. So my overall take, honestly, just starting as a person and as a woman who has been pregnant several times, I don't believe her for a second. And it's because it would have been so easy to establish a pregnancy that it just doesn't make sense that we are cobbling together photographs of medical records that are not the right medical records. I mean, even people who are not in high-risk pregnancies, they go in and they get a dating ultrasound when you're 12 weeks, when you're 11 weeks, when you're 10 weeks, right? That already, just as a woman and as a person, I don't believe it. I didn't see anything in her opinion. I don't know the law in Arizona on this stuff. I didn't see anything in her opinion that looked questionable to me. And I really think she went out of her way to make clear that these were credibility determinations she was making, being the only person, the trier of fact in the trial, who was assessing these witnesses' credibility in real time, and she found them to not be credible. And having done that, that really shores her up for an appeal, because that's going to sort of bolster any type of, oh, was there enough evidence here? Was there some evidence of this? She's basically made a good case that she didn't accept Laura's testimony or evidence for several very compelling reasons, including that she lied under oath in other instances, including the fact that she could have produced better evidence and chose not to, right? Because that's something that legally, if there were a jury here, the judge would instruct the jury, you should consider that. The fact that she could have had better evidence and doesn't. That is something you should consider in deciding whether to believe her. So I'd be surprised if they win an appeal. But again, an appeal would probably be based on some hyper-technical violation of Arizona law, some failure to meet one of the criteria for establishing a case that I'm just not familiar with off the top of my head. So there could be a basis for an appeal, but an appeal is not going to be successful because an appellate court says, no, we think Laura was telling the truth. It's not how it works, and it's also not going to happen.
Yeah. No, that seems to be the consensus. To play devil's advocate, David Gingras, her lawyer, just has a hard time accepting he's lost anything in this case. In that blog that he wrote, he absolutely 100% convinced they are going to win an appeal based off, he would lay out all these legal things that I, don't understand. Was there anything in that blog that he wrote where you were like, okay, he's talking in, obviously he's talking about Arizona law and you say you're not familiar with it, but was there anything in there that he did say legal technical terms that were like, oh yeah, they might be able to get her on or get the Woodnick firm on this?
No, there was nothing I saw. And also tellingly, a lot of that blog was devoted to him explaining that he had asked to disqualify the judge, and she had made a ruling anyway, which, by the way, that's not allowed. So he's right about that. She wasn't allowed to make a ruling after disqualification was sought. However, you don't move to disqualify the judge when you have a good basis for an appeal. Right? I mean, it's just like, that's like the desperate man's move, right? Trying to disqualify the judge a day before trial, or try to disqualify the judge a day before she makes her decision. It's not something you do when you know that you have a procedural slam dunk appeal, right? There are certainly times where both could be true. You could have a basis for disqualification and you could have a good basis for an appeal. But the way that this kind of unfolded, he's throwing things against the wall is what it looks like to me. So there was nothing that sort of jumped out as, oh yeah, that's a good point, except what I just mentioned. He is correct, and I don't know how this will unfold, that when disqualification is sought, rulings they make are typically void. So we'll have to see how that unfolds. But I don't know the timing of when this particular decision was made versus when a subsequent decision was made. And that won't really matter, because that's not going to undo the entire trial. That was the very last decision she made in this series of decisions. So it's, other than that, there wasn't much that I saw that sounded like, oh, this is an interesting counterpoint.
Yeah, and I think what happened, and I could be wrong because it's been a while, but I think what happened was she was already in the process of making her decision when he filed that, so it kind of overlapped. And then I think they did bring in another judge and already had settled all of that. And the judge, yeah, I think it got settled really quickly, and then she had to resubmit her decision. But it was kind of like it all kind of came in at once, I think that's how it went. So I think that's all buttoned up.
Yeah, that makes perfect sense, because that's what happens when you move to disqualify a judge. you have to go basically outside, obviously, that judge's circle to have somebody independent rule on it. In California, where you have to go to another county, you can't even have any of the county judges rule on your motion. So it would make sense that a third-party judge came in, maybe from a different county, decided she wasn't going to be disqualified, and then she reissued the decision. That would make perfect sense, and then it's fine, right? Because
that was all done within a week, I believe.
Yeah, makes sense. And appealing a disqualification of a judge is also extraordinarily difficult. The standard for disqualifying a judge for bias is so high, and I didn't see anything. The fact that her father sat in the gallery, or that her father likes The Bachelor, is really silly. I mean, judges around here, have dinner with lawyers, socially, and they're not disqualified from their case, right? There's nothing inappropriate about that. So
yeah, it seems as though he just wants to sow doubt so that when people Google this, there is doubt. But it doesn't take much for people to, supersede that. I mean, yeah, if I was a retired judge like her father is, or retired Laura, I'd be at the courtroom every day. That'd be such fun. So yeah, it's just no one saw it. Everyone saw through that.
It's a curious definition of fun, but I get it.
Well,
juicy.
Yeah, it's funny. The last thing I want to say is I just want to go back to a point that Dave made earlier about like nobody coming to Laura's defense. I've been covering The Bachelor for 15 years now, and people come to me all the time and say things about contestants and whatnot, and you get people on their side defending them. When Dave and I started covering this last September, and here we are, Halloween, we started covering this September of 2023. Here we are, Halloween of 2024. I am 100% honest with you when I say that, especially when you start talking negative about a person, and Dave and I have always put out there that there's holes in this story. We don't believe it. And then obviously more and more evidence came forward. But just the idea of, it's so easy to prove you're pregnant. This chick is running through hoops to show us that she is. She's acting like someone who isn't pregnant, who's trying to prove to us that she is. Like, that's been my opinion the whole time. But at no point during these last 15 months, not one person has emailed me, even saying anonymously, Steve, I know Laura, you guys are wrong about this. You probably should back off. You would think that one person would come to her defense and just say something positive about her. She's got nothing. And it's amazing considering the way she talks about herself in her blog and claiming to have all this support, because she only puts out on her blog her side of the story, which of course, when you read her blog, you're like, wow, Clayton's a horrible human being. It's just like, yeah, but you don't know Clayton's side and you don't know what Laura has done. And then she says, well, I know I never did any of that. It's like, okay, well, that's never going to believe it then.
It's really remarkable how one-sided it is, particularly given that he's the Bachelor, right? So there's got to be people out there who just don't like him, who have already decided, I watched that season, I didn't like him, I've made an opinion about him. But also, he didn't necessarily behave in the most upstanding, gentlemanly way in his encounter with her. It would be so easy, I feel like, for some people to come to her defense in the name of womanhood, in the name of motherhood, to say, you know what, I believe her. I'm going to take her at her word. And this is kind of a scumbag for how he treated her and lied about her real estate deals and, had this little encounter and then broke it off with her. You'd think somebody or a few somebodies out there would jump on that bandwagon. I think it's really remarkable that nobody has.
Yeah, a childhood friend come forward. I've known her for years. Steve, she's not, she can be a little, loopy at times, a little crazy. And it's just amazing that not one person. And I just think that, a lot of people have this opinion. I know Dave has shared it and I've shared it. It's just, and I think even she has kind of said, like, I was not popular in high school. She's kind of put it out there that she was a late bloomer when it came to sex. So it really does seem that there is something there, some sort of attachment where the fact that one guy did pay attention to her and she did get to have oral sex with him, that she would immediately become attached to him and want and think that there's something more there than it isn't, when this was literally a case of dude hooked up with a girl one night and didn't want to have anything to do with her after that. And then she just could not get that out of her mind. And like, wait, what, why? And it kind of all adds up now when you see and you read things about her and things that she's talked about in the past. Like, she just mentally, I think she needs help. And we've said that from the beginning. Like,
yeah, absolutely.
And Dave brought up the best point. If she would, at some point, it's too late now, but if at some point she would have just said, you know what, I got carried away and I was in a bad place. And you even make up why you were in a bad place, but I was in a bad place mentally. I took it to extremes that I shouldn't have. I'm sorry. And, even write a book or do a podcast explaining why. She would have gotten so much more sympathy than continuing to double, triple, and quadruple down.
I know. And I even think she could have gotten away with convincing people that she was briefly pregnant if she had come out on top of things and said, I really was pregnant, but I lost it very early and I couldn't accept it. And I was devastated and I was going through things in my life. And I just really couldn't let go of this, fact that I was pregnant and I wanted it to be true. And I wasn't, I think she might have been able to convince people she had been pregnant and that she just kind of got carried away and, made all these mistakes. And again, I don't even think she would have been sanctioned if she had done that. But it was just, she let it go so far. I don't know, maybe she'll still do it. She doesn't really seem to be the best decision maker, but it would be a fascinating story if she decided to come out and say, here's what I did and why. She
could have said, I miscarried at 6 to 8 weeks in my own bathroom. We never would have been able to prove anything. She could have claimed I was pregnant for 8 weeks. I lost the baby. But the second she's at that pretrial hearing with a fake baby bump, it's like, wait a second now you've essentially perjured yourself, because not only did you say I'm 1000% pregnant, 24 weeks, here's my baby bump. And she literally showed it on the pretrial hearing. And it's like, okay, well, wait a second. Now Gingras is claiming that you might have lost the baby in July. Well, if you lost the baby in July, how did you have a baby bump at 24 weeks at a pretrial hearing under oath saying that? It's just, she absolutely perjured herself.
And no doubt they have told her now she can't say anything, because particularly if this is being investigated in any way, she has to zip. Like anything she says is just going to get her into more trouble at this point. So at this point, we're not going to try to pin it to July or October. Like, you got to stop giving them fodder for their prosecution of you is really what you should be doing. And that's why that was so devastating that he came out and accidentally admitted that it was her sister's ultrasound, right? I mean, that is it's going to harm her prosecution, right? It's going to give them yet another piece of evidence.
Yeah. And when you look at that timeline, her sister's baby was born end of May, beginning of June, right when she had that whole, the sex with Clayton, the hookup with Clayton happened May 20th, 2023. Her sister delivered her first baby like end of May, beginning of June of 2023. So it's almost like, I don't know, living vicariously through her sister. She sees her sister give birth, and now she wants to have a baby because she said, hookup with Clayton happened on May 20th. I was pregnant on June 1st, which again, I've never gotten anybody pregnant that I know of, but that seems really early that she said, I know I was pregnant on June 1st when you had a hookup on May 20th. You don't know. You might, a stick might tell you are, but you're not legally pregnant 11 days after you have a hookup, right? That's just not.
I don't know. I mean, I think you can have a positive test depending on when in your cycle you are, but there's so much else here. And right, the sister having the baby, that's another, if she had just done the apology tour. My sister just had a baby. We know she has polycystic ovarian syndrome, which usually makes it hard to conceive. It's something that women deal with that is really devastating, and it's really hard to live with, particularly for someone who wants to have children, because it can often make it very difficult, if not impossible, to conceive. All of these things could have been part of a very compassionate story about why this went off the rails at some point, if that decision had been made a year ago to just pull the plug. But it wasn't. And so you end up here, and hopefully, this will be a cautionary tale to folks in the future that if you take it too far, there can be actual consequences. I mean, there's already a monetary consequence, but maybe more consequences.
Does Clayton or his lawyers ever see that money? I mean, there's been talk of they're never going to see a penny of that.
It depends on if she has it or not, right? The court can't produce the money for her. If she in fact has real estate that she has an interest in that is not underwater, there are ways once he's got a judgment to basically execute on that. It's very hard to get that money. And if she doesn't have it, he's never going to see it. It seemed to me like the court in the financial analysis concluded that she has it. the issue is, it's not that hard to hide once you have it, to keep it away from a judgment, right? You move it into an account they don't know you have, and it's very hard to track down. And you could easily spend more than $100,000 trying to get that $100,000. So my guess would be he'll, if this is upheld on appeal and they go after it, he'll do the basic stuff to try to execute on the judgment. But the chances of getting all of that money are probably slim. It's not that hard to stay away from a judgment creditor.
If she sells a book or her podcast receives ad revenue, would they be able to garnish those wages?
So they could garnish wages if she has an employer. If she is getting revenue from a podcast, I don't necessarily know that there would be an employer where she's getting garnishable wages. They could certainly attach a bank account. If they could find a bank account that she is putting money into, they could basically seize the money from a bank account. And they could potentially, if she's getting money from like YouTube, they could subpoena YouTube to find out where they're depositing money and then attach that bank account. There are certainly ways to do it. It's just, as you can imagine, everything I'm saying takes a lawyer, right?
Yeah.
So
And I have no belief that she's actually making any money. The karma is that she got $100,000+ from a contractor named Sean, a Native American that she took advantage of when she changed the plans she wanted. And she actually used the system against him. It's a completely parallel story that doesn't involve sex, but another case of control where she did the same thing. And as a nice guy with a new business, he sunk everything into trying to, do what she wanted and ended up losing out, in another way. So reckless, and there's probably more that we don't even know about.
I wouldn't be surprised if we saw something about a vexatious litigant at some point.
Wow.
So that she has to get, special permission before she can file more lawsuits. I'm not sure she's hit the number threshold because it has to be a high number, but certainly in terms of the nature of these lawsuits, they certainly rise to the level of, harassment and impropriety. So it's just a matter of like, are there enough on record?
And I guess one final thing, again, just your opinion on this, reading Mata's judgment, knowing that she is being, they're investigating her criminally. And I know that you said you've never really seen this in the family court, in the family court. Just your opinion. Do you think that she does get indicted on this?
I don't know. I think I would be surprised if there was simply a perjury indictment. If they pursued this all the way just to establish one instance or two instances of perjury. I don't know for sure because of the I don't know how busy the DA's office is. I don't know how many resources they have. I certainly think if they asked for an indictment from a grand jury, or if they went about an indictment another way, I don't see any problem having an indictment returned. The question to me, there's more than enough, and a grand jury, if that's the indictment process in Arizona, would hate her, just like the public opinion has hated her, right? Yeah. But the question is whether they actually pursue it that far over what could be just misdemeanor charges.
Yeah, criminal charges. Yeah, just
criminal. Yeah. Whether they want to put all of that time and energy and resources into a perjury prosecution. Or whether they're looking for something more, which I think they might be able to find at this point, extortion, things like that. Especially if there's all these other people involved in other things with her that aren't necessarily the parallel, but who knows? And this might be a nice opportunity to get some press in Maricopa County. I don't know. Yeah. Which is not a bad thing, by the way. It's not a bad thing to sort of make an example of something like this. For deterrent purposes. That's not, people will say, oh, they're trying to do this, to get press and to make an example of them. That's not bad. That's part of what the criminal justice system is for.
Well, obviously, we're going to be keeping an eye on this. Obviously, you said it could take a while for the appeals process. I would think we will know if she's going to get charged criminally, I think probably before we find out about the appeals, right? I mean, I don't know how long they have. They can take however long they want this investigation that's going on. When do you see an answer for this?
Limitations. Yeah, there are statutes of limitation in terms of how long it takes to bring a case.
Okay.
And I can't imagine that perjury would be several years down the road. So yeah, I would imagine that, it may be that some of the conduct they actually can't even prosecute because it's past the statute of limitations. for the guys 10 years ago. But yeah, I would imagine they can't just take forever on an investigation. They have to move on it with some speed, like in the next year. And my guess is that'll happen before the appeal is resolved.
Okay. Well, Rachel, thank you so much for coming on. I'm so glad we were able to have you on this, and a great discussion for 90 minutes on this case. It's taken up a lot of Dave's life for the last 15 months, and mine not nearly as much as Dave, but it's still a fascinating case, because as much as we talked about in this 90 minutes, there's obviously so many other little things that have happened that people are just like, I can't believe this. Obviously, there's documentarians looking into this right now. And, if it ever does come out, people will see the scope of her behavior was so far beyond just, oh, I thought I was pregnant and I wanted to essentially, get this guy to like me and get this guy to date me. It was just so much more deeper and sinister than that people I think will be amazed if that ever comes to fruition.
Yeah, I see a lot of stuff. And I even told you this was even crazier than I really could have imagined when you said this is really nuts. And I'd heard a little bit about it. Yeah. Actually digging into it, this still like clears the hurdle by a lot of crazy.
Great to hear. I mean, I knew it would be, and I don't even know how much of the stuff you got. I mean, Dave produced over 100 videos, and I don't think you
I saw a couple of them. I did something beyond what you gave me, but
okay.
I certainly did not see all 100 back.
Don't bill us for the hours you spent.
Right? Don't worry, I'll send my bill over.
Rachel, thank you so much for your time. I know you're a busy woman, so I appreciate you coming on for 90 minutes. Thank you again so much.
You got it.
Thanks.
Take care.
Anytime, guys. Take care.
Bye.
Take care.
Bye.
Good stuff.
Let's see here. End record.